the Oregon people voted barely on a proposition called Prop 114. And what this essentially did was two things. Number one, it basically made all standard capacity magazines illegal to possess within the state of Oregon. Very similar to what California had originally tried to do. It also had a secondary effect. Those looking to get a concealed weapons permit in Oregon would now have to go through a relatively extensive permitting process, which could include psychological evaluations, among a whole other host of things. Now, in today's video, we're going to be talking about the Oregon Firearms Federation v. Kotek. I'm sure many of you have probably already heard about this decision that was handed down by Judge Karen Immergut. The Oregon Federation of Firearms sued to call this case to be unconstitutional, this statute to be unconstitutional. And apparently the good Judge Karen Immergut disagreed with their assessment. Now, a little bit about this judge. You know, one of the things that I've heard a number of people say before is that Donald Trump did at least one good thing, and that was he was able to secure a number of pro-gun judges within the judiciary. And there is no question, there have in fact been a number of judges that are sitting on various courts of appeals as well as district court benches that have in fact ruled in favor of pro-gun decisions. But it has not been exclusive. The Ninth Circuit has been saddled with a jurist that Donald Trump put on it that had originally been the Attorney General of Hawaii. And he is incredibly antagonistic to the Second Amendment. And we have now learned that Judge Karen Immergut also bears the same level of hostility. What is fascinating is the way she has determined that this Proposition 114 is in fact constitutional. One of the first things she says is that the plaintiffs, specifically the NSSF, who was also a plaintiff in this case and provided expert witness, did not provide any robust evidentiary, information. The expert witness that talked about the number of standard capacity magazines that are in the marketplace, she found to be completely worthless. Not only was this individual relying exclusively on industry standards, which I find to be fascinating in and of itself, but she effectively says the mere presence of standard capacity magazines are not enough to create constitutional protections. She goes into this when she goes into her common use argument, which we've heard a number of times before. She also does what all sorts of anti-gun judges have been doing, which if you've seen some of my previous videos, absolutely infuriates me. They totally misquote Heller. I'm pausing this video to remind you that USCCA, who sponsors these videos, is doing a secret giveaway. And you can find all of the information in the description below on this video. You're gonna want to get involved in this pretty soon. It does end. So, I can tell you what they're giving away. It's pretty cool. You're gonna want to participate. So remember, we have two separate decisions that we really look at. We look at New York State Rifle and Pistol Association v. Bruin, the most recent one, which gives us our, Second Amendment text and then informed by the history of firearms regulations at the time of the ratification. But we also look to Heller specifically to see whether or not the conduct or the statute implicates the Second Amendment in the first place. Remember, that is how we do the analysis. The plaintiff says, my rights are being affected, my Second Amendment rights are being affected by the presence of this statute. They have to overcome a hurdle. They have to actually show that their Second Amendment rights are being affected. Then the burden shifts to the state to show how the statute is in fact constitutional because it comports with our history, our nation's history of firearms regulations at the time of the ratification. So there's been a number of challenges to whether or not the Second Amendment is even being implicated in the first place. And this judge does the same thing. Now, what's also interesting is that with the Bruen decision, the Supreme Court specifically said, we are done with interest balancing tests. The state may have laudable goals in protecting human life, right? And yeah, they could theoretically make a law that says, murder is illegal. There's an idea, huh? But if they were to sit there and they were to say, look, we're going to go ahead and we are going to create a law that restricts the ability to use any sort of tool whatsoever for both offensive and defensive use, whether it's a gun, a knife, a rock, a baseball bat, it doesn't make any difference. If you use a tool, even for self-defense, you are in commission of a crime. All right. In fact, if you are holding a tool that could be used for self-defense, whether you have any intent to do so or not, you are committing a crime. So they could do that, and they would say, look, we are doing this because we have an interest in protecting public safety. Okay, fair enough. Then they would look at the individual plaintiffs and they would look at the fact that their Second Amendment rights are being implicated, and they would try to do a balancing test. In Bruen, the Supreme Court said, stop it. You're not allowed to do that sort of test anymore. The interest balancing already took place during the ratification of the Constitution. That's done. So, of course, what does this judge do? She goes through an interest balancing test. And as I said, she misquotes Heller again. In her opinion, Heller states very emphatically that the Second Amendment only protects weapons that are in common use for self-defense. That is not what Heller said. What Heller said was that the Second Amendment protects weapons that are in common use for lawful purposes, such as self-defense. It's a bigger, more expansive concept. But a lot of judges have essentially made the argument that nope, the only purpose of the Second Amendment is for self-defense. And as I've said before, if that is in fact the case, if that is truly the purpose of the Second Amendment, then my Winchester Model 70 loaded in .30-06 that I use to hunt North American game, that bolt action rifle is not protected by the Second Amendment. After all, a Winchester Model 70 chambered in .30-06 is very rarely used for the purposes of self-defense. All right, that's not what the law says. It's not what the decision says. But these judges, rather than sitting there and coming up with intellectual arguments to try to navigate their way around what their restrictions are from their superior court, have essentially just decided they're going to make it up, or in worse, they're actually going to plagiarize and lie about it. Okay, and that's effectively what this judge has done. So she goes through and says, look, standard capacity magazines are simply not in common use. All right. And again, we get into that granular analysis of what is use. And it would appear that her argument is mere possession is not sufficient for use. That use means actually using. Okay, and we're going to get really specific, not using at the range, not using in training, not using as you're displaying it to your friends. It's using for the purpose of self-defense. And self-defense, more specifically, will be defined not as having a firearm at your ready in case someone breaks into your home, but using a firearm after someone has actually broken into your home. That's when self-defense kicks in. And they say, well, you know what? In actual shootings, that looks like the majority of people use 1 to 7 rounds. Now, look, I'm going to be blunt. The number of rounds fired, I find to be completely irrelevant. It's a red herring, okay? Because as I said, going to the range, you fire a lot more than 7 rounds, all right? So in my opinion, common use is more expansive than simply self-defense. So, but they make this argument nonetheless. And then, guess what? She does a balancing test. She starts talking about the brand new societal issue of mass shootings and goes through that same ludicrous trope that, well, if someone has to change magazines, that offers a momentary pause for people to be able to hide or launch a counterattack or something to that extent. There has been absolutely no evidence ever proffered that that actually occurs, all right? But they make up this stuff as they go along. These judicial decisions are not being grounded in legitimate, rational reason. These judicial decisions are being grounded on the outcome that they are seeking to achieve. And it's getting to the point of being utterly ludicrous. We have now reached the point where all of us can look and see a rock. We can all look and we know it is a rock. It has empirical evidence. We can see a rock without even touching it. We know this rock has certain material qualities to it. It's hard. It has the potential to injure someone. And yet, the courts have said that's not a rock. It is, in fact, a marshmallow. We have gotten to that point where we're looking at it saying, no, Your Honor, it's clearly a rock. And they're looking at us like we're idiots. And they're saying, how can you possibly say that? That's clearly a marshmallow. Well, why is it a marshmallow? Really? Do I have to go through the long legal analysis to tell you why it's a marshmallow? Simply accept the fact that it is a marshmallow. Literally, this is where we're at right now. So, and then of course, and interestingly enough, she gives very short shrift on the permitting requirements to getting a concealed weapons permit. Effectively, she just dismisses it and says, yeah, it's perfectly fine. Not a problem, doesn't affect Bruin whatsoever. States can go ahead and create as many barriers as they want. You know, after all, once again, the Second Amendment is something that can be easily dismissed out by simply coming up with some sort of intellectual justification for doing so. This is something that is absolutely going to be going before the Ninth Circuit Court of Appeals. What is also interesting is that we're still waiting for our decision in Miller v. Bonta from Judge Benitez, where we suspect Judge Benitez is going to take the entirely different argument. So we may very well see 2 competing lawsuits effectively over the same thing, where we have one judge that says, no, the Second Amendment is completely irrelevant, doesn't apply to anything. In fact, how dare you even think that the Second Amendment would potentially apply to firearms? And then you have another judge that says, now I think it's pretty clear that the Second Amendment does in fact apply to magazines, and there is no historical regulation that would implicate the idea that standard capacity magazines are anything other than constitutionally valid items. So we're going to end up having both of these go before the Ninth Circuit. I have absolutely no idea how the Ninth is going to, in the final analysis, come to its decision. The court, interestingly enough, in the past, we could sit there and we could say, look, any gun case that makes its way to the Ninth Circuit is going to find that gun control is perfectly constitutional. That's not necessarily the case anymore. There's almost a certain degree of parity between the justices that serve on the Ninth Circuit. About half are pro-gun, about half are anti-gun. So the makeup of judges we get will largely determine how the Ninth ultimately rules. But this may very well be one of those cases that are also going to be going up before the Supreme Court. The Supremes have already said that they are going to be ruling in U.S. v. Rahimi. Now, that case is very, very specific as it relates to prohibited persons, but it may very well go into a larger analysis of what lower courts are doing, much like this one in Oregon, in completely screwing up the directions that they have provided in Bruin originally. We'll have to wait and see. Until then, if you have any questions and would like to contact me, you can certainly do so at steven@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.